So there it is. Mukul, let me start with you and ask you the question. What do you think is fundamentally wrong with the system?
With the judiciary?
Yes.
I think, Kapil, there are a host of factors. It's not possible to pinpoint only one. The nature of appointments, the fact that judges have usurped the power unto themselves to appoint, virtually saying that we know the best and we don't want any other person to be in that appointing authority, whether it be a lawyer, whether it be a member of the government or anybody else. And in that context, there is no transparency. Even today, there is no transparency, except now there is a short note coming out that we have appointed or looked at X, Y, or Z, but that's not transparency. They don't say how many people we have interviewed, how many people we have seen, etc. we have appointed. That's not going on. So that's a problem of appointments, which I personally feel has gone on even beyond the NJAC case. There is no law which allows the court to appoint members to the court. There is no law.
There is a judgment of the Supreme Court.
There is no law, written law of Parliament or the Constitution of India which allows that. It has been so interpreted, and I think wrongly with respect, to keep the power to yourself. That is one problem. The other problem is that we have cases clogging the courts. And it is going from bad to worse. The system is collapsing. The collapse has started. And I would only recount what I read in the paper about Allahabad High Court, in which you had appeared.
Yes.
And the court made very disconcerting remarks. Yes. People are losing faith because of clogging of the system. Clogging is because of a variety of reasons. Again, the quality of judges who are appointed, their capacity to dispose of cases, the myriad laws and the labyrinth of laws which requires to be simplified. You look at the Income Tax Act, it is this thick. Nobody can understand by the time you are done with it. So you don't simplify laws.
The sentence runs into paragraphs.
So you don't simplify laws. You don't simplify the nature of resort to appeals. Laborious laws, some going back from 100 years, going on and on. That's yet another aspect. And ultimately, the stuff which is being appointed is frankly, if you ask me, not up to the mark for various reasons. Sometimes that person has no experience. In the sense, in the last 25 years before you become a judge, you've done hardly few cases. If you don't have experience, you're not able to deal with the job. You're not up to the mark. So I would say these are a host of factors which is afflicting our judiciary, and a multi-pronged approach is required, starting from the manner of appointments, the declogging of courts, simplifying the laws, simplifying the nature of appeals, and then we can look at something. Otherwise, I'm sorry to say that in our lifetime itself, this system will completely collapse.
But tell me, on the manner of